Hi, my name's Emily Kyle. Our question of the day today is, what does it mean when somebody says, did you fund your trust? So, lawyers, like any other profession, have words we use for things that are just our words. And I understand a lot of times they don't make sense. Just like in your profession, I wouldn't understand what you're talking about. So, funding the trust just means making sure that either title to that asset now has the trust name on it, or that the trust has now been named as a beneficiary of that asset. So, for example, if I have a bank account and it just says Emily Kyle and I have a trust, but the trust name isn't on that asset, then I haven't funded my trust. So, if I pass away, that bank account still might need a probate in order for somebody to collect the bank account and then get it to my trust so the money can be used for my benefit if I'm still alive or for the benefit of the named beneficiaries. So when you put the name of the trust on the asset, so you go to your bank, your checking account, savings account, money market account, CDs, and now it says the Emily Kyle Trust on it, then the successor trustee would be able to access that account, again, in order to take care of me if I'm alive or pay my final bills and do the normal trust administration. You do not want to add the name of the trust onto your retirement accounts, your 401ks, 403bs, your SEP plans, your Roth IRAs. That should just stay in the name of the wage earner, or the IRS considers that to be a distribution. You can name the trust as the beneficiary if you want, or you can name individual people. You can title real estate to the name of a trust. You can have a company where the member or the stockholder is your trust. And then all of your non-retirement investment accounts can have the name of the trust on it. We have heard from lots of clients that banks make that a little bit more difficult than the process should be. And so if it's easier to just name the trust as the beneficiary, at least the money would go where you want it to go when you pass away. But understand then your trustee does not have access to that account because they only have access to assets that are titled in a trust. So then your agent under a financial power of attorney would have to access that account in the event that you became incapacitated. So I know it's super confusing. If you have questions, give us a call or talk to the attorney who helped you set up your estate plan or your financial advisor. And we really appreciate the questions. So if you have other ones, please shoot us an email and we'll try to answer them. Again, I'm Emily Kyle. Thank you so much for listening.